"Free my teacher! I'll expose the killer!" The court laughed. Then a man ran. The courtroom was full that Tuesday morning in Vancouver. The British Columbia Supreme Court chamber was imposing the way old public buildings know how to be. Dark wood paneling covering every wall from floor to ceiling. The golden Canadian coat of arms embossed in relief behind the judge's bench. Symmetrical rows of gallery seats separated by a central aisle that felt more like a cathedral nave than a judicial hall. The tall windows allowed in a cold, diffuse light, typical of the Pacific Coast autumn, the kind of light that does not warm anything. It only illuminates, illuminating tense faces, hands clasped over notepads, and the closed expressions of those who already know this day will end with a verdict. In the gallery, journalists adjusted their notebooks and pens. Cameras were not permitted inside the courtroom, but stairs were, and everyone was staring at the same place. The defendant's chair on the right side of the hall, just behind the low, varnished wood railing that separated the public space from the space where justice was supposed to happen. Sitting there was Daniel Mercer, 42 years old, a science teacher for 15 years. Dark brown hair with threads of grey beginning to show at the temples, as if the past weeks had accelerated something that should have taken years to arrive. Deep, hollow circles under his eyes, the kind that are not formed in nights, but in weeks of sleeplessness. His hands were fitted with discreet handcuffs, connected by a short chain to the belt of the orange jumpsuit issued by the British Columbia Correctional System. He stared straight ahead, at nothing in particular, wearing the expression of someone who had convinced himself, somewhere between the arrest and that morning, that the world had decided his fate long before any formal judgment. It was the expression of someone who had stopped fighting, not out of cowardice, out of exhaustion, because there is a point at which resistance feels like nothing more than a delay of the inevitable. And that point arrives slowly, day by day, cell by cell, like water rising without making a sound, until everything is covered. Daniel Mercer had been charged with first-degree murder. The victim, Thomas Breyer, 44 years old, a local real estate businessman, found dead in Jericho Park at around 10 o'clock on a Friday night in October, with 2 shots fired at close range to the chest. The weapon had not been recovered. The motive, according to the prosecution, was a documented financial dispute. Thomas Breyer had lent money to Daniel years earlier, when the two men had been acquainted through a mutual friend, and payments had stopped. A debt that, according to the bank records presented in court, had grown to 92,000 Canadian dollars, with accumulated interest. The evidence presented by the prosecution was, according to every legal analyst who had commented on the case in the days that followed on television and radio, difficult to contest with what was available. Fibers from the specific jacket Daniel Mercer wore regularly, a dark blue winter parka, had been found on a bush 3 meters from the body. Daniel's cell phone number appeared in the records of received calls from Thomas Breyer on 12 of the 14 nights preceding the crime, always after 11 at night, short calls between 2 and 8 minutes long, calls that Daniel described as aggressive collection demands and that the prosecution characterized as evidence of an escalating conflict. And there was a witness, Robert Finch, 58 years old, a resident of the neighborhood, who had declared under oath with apparent conviction that he had seen a person matching Daniel Mercer's physical description, height, hair color, the blue parka, walking toward Jericho Park at around 8:40 that night. Daniel had denied everything from the very first interrogation. He had said that the calls were from Thomas Breyer, not to him. That Thomas had been pressing him about the debt with increasing intensity and a tone that had begun to feel threatening in the final weeks. He had said that on that particular night he had been at school preparing material for the following Monday's lesson, that he had stayed until after 9, that he had not gone anywhere after that he had taken the bus straight home. He had said all of this with the stubborn calm of someone who knows the truth exists, even when no one around them can see it. People who knew Daniel Mercer described him consistently in ways that made the charge against him feel not merely improbable, but categorically wrong. He was the teacher who stayed late without being asked, the one who remembered which students had difficult home situations and quietly adjusted deadlines without requiring explanations or public acknowledgement. The one who kept a box of granola bars in his desk drawer, because he had noticed early in his career that some kids arrived at school without having eaten, and he understood that hunger was hard to think through. He was not perfect. He had a dry, occasionally misjudged sense of humor and a slightly embarrassing enthusiasm for chemistry puns that colleagues had long since given up trying to discourage. But he was good at the core of his work, the way the best teachers are good, not as a performance, but as a habit, a default setting that operated whether anyone was watching or not. He had borrowed money from Thomas Breyer during a period of genuine financial difficulty. He had been making payments. The payments had become irregular when a series of unexpected expenses compressed his budget in ways he had not anticipated. He had communicated this to Thomas. Thomas had responded with escalating pressure and in the final weeks with late-night calls that Daniel had found troubling enough to start documenting in a notebook he kept in his desk. A notebook that Ronald Chung had not had time to fully review before the trial began. None of this had been part of the story the prosecution told, and the prosecution's story had been told first and told well. And by the time it reached the jury and the press, Daniel's quieter and more complicated truth had no platform, no advocate with enough time, no voice loud enough to be heard over the architecture of evidence that had been built against him. But denial was what many innocent people had offered before being convicted, and the system, with its impersonal efficiency, had moved forward anyway. Judge Harold Fenwick presided over the case. 63 years old, 3 decades of career, and the accumulated experience of hundreds of judgments condensed into an angular man with impeccably combed white hair and a posture that did not admit ambiguity. Half-moon glasses perched on a sharp nose, a deep, measured voice that filled the room without effort, as though the acoustics of that historic building had been specifically designed to carry that voice from one end of the hall to the other, without losing a single syllable. He was known in legal circles as meticulous, precise, and completely intolerant of what he called unnecessary legal theatrics. He did not like surprises, he did not like deviations from protocol, and he absolutely did not like having his time wasted by anyone, regardless of status, intention, or circumstance. That morning, the case was moving toward the natural conclusion of weeks of hearings. The prosecution, represented by the experienced and technically relentless Adriana Walsh, had closed its final arguments the day before with a concise, structured, and devastatingly organized presentation, the kind that leaves no visible gaps for emotional contestation. The defense, conducted by Ronald Chung, an overloaded public defender with a caseload that far exceeded what any reasonable human being would consider manageable, had presented his arguments the previous morning with a conviction that, for anyone who knew how to read the body language of courtrooms, looked more like professional resignation than genuine belief in his client's innocence. Ronald Chung was competent. He simply did not have the time or the resources to be more than that. The jury was waiting in the adjacent room. Everything indicated that before noon, deliberation would begin, and that before the end of the week, Daniel Mercer would be convicted of murder. But no one knew what was about to walk through the side door of the gallery. No one knew at all. Maya Correa was 11 years and 3 months old. She had woken at 5:50 that morning, long before the alarm she had set for 6:15, because she had slept poorly and briefly, as she had slept for the past 3 weeks. She had lain still in the dark of her small bedroom for a few minutes, staring at the ceiling, listening to the quiet apartment and the street below that was already beginning to move with the first buses of the day. She had thought about Mr. Mercer. She had thought about the folder with the documents. She had thought about everything that could go wrong, and she had decided, for the 100th time, that she had to go anyway. She got up at 6, showered with the lukewarm water because the hot water took too long to arrive, and braided her own hair in front of the small bathroom mirror. 2 long braids, as symmetrical as she could make them, fastened at the ends with the blue hair ties from the shelf. She put on the St. Andrew Primary School uniform, a navy blue blazer with the embroidered gold crest on the left breast pocket, a thick plaid skirt that reached just below the knee, grey knee-high socks, and black shoes with a side buckle that her mother had bought at the start of the school year and that were still nearly new. The same uniform as always, the same girl as always on the surface. But this was not an ordinary day, and she knew it the way you know when something is about to change. Not with joy or fear exactly, but with a quiet certainty that does not ask permission. She left a note for her mother on the refrigerator, held in place by the small blue whale magnet that Fernanda Correa had brought back from a short trip to Tofino 2 years before. She had considered leaving a voice message, but she knew her own voice might betray the tension she was carrying, and if that happened, her mother would call back immediately and Maya would not have enough arguments to convince her that everything was fine. So she wrote that she was okay, that there was something important and urgent she needed to do related to Mr. Mercer's case, that she would be careful, that she would explain everything when she got home. She picked up the brown synthetic leather folder that had belonged to her grandfather Antonio, who had died 2 years earlier and whose faint smell of pipe tobacco still seemed to linger in the material, or perhaps she only imagined it did. It was the most serious-looking thing in the apartment. Inside, it was everything. Documents organized with color-coded paper clips, each one with a small, handwritten label in careful, controlled lettering. She had spent 3 weeks assembling those documents, 3 weeks that had begun the evening she saw Mr. Mercer's face on the 6 o'clock news, surrounded by police officers, and that ended on this cold Tuesday morning in Vancouver. 3 weeks of phone calls that sometimes no one answered, of visits to commercial establishments whose employees looked at her with surprise before, almost invariably, agreeing to help, because there was something about the seriousness of her manner that was difficult to dismiss, of online research on legal websites using the old computer in the living room, of letters written with a dictionary open beside her to make sure every word was exactly the right word, of conversations with adults who initially tried to treat the whole thing as a child's confusion before realizing, partway through her explanation, that it was anything but. 3 weeks of investigation that no adult had thought to conduct. Maya had first tried the proper channels because she believed in proper channels. Mr. Mercer had taught her to believe in them. He had a way of explaining how institutions worked, courts, police departments, school boards, not as sacred things, but as human constructions, imperfect and improvable, and worth engaging with, honestly. He had once spent an entire lesson talking about civic responsibility, about the difference between complaining about a broken system and doing something about it, about how the most meaningful participation often came from the least expected places. She had taken that lesson seriously, in a way that he perhaps had not expected when he taught it. The night after she saw his face on the news, she had called the non-emergency police line and asked to speak with someone about the Mercer case. She had been told that the case was under active investigation and that information from the public could be submitted through the online tip portal. She had submitted a tip through the portal, a careful, detailed account of where she had been on the night of October 14th, what she had witnessed, and what the school exit records would show. She received an automated confirmation number. Nothing followed. 4 days later, She had gone in person to the offices of Ronald Chung, Mr. Mercer's public defender, after school and waited in the reception area for 40 minutes before being told by the receptionist in a kind but final tone that Mr. Chung was unavailable without an appointment and that the most efficient way to reach him was through the court-assigned communication portal. She had written through the portal. She had not received a reply. She had looked up the email address of the Crown Prosecution Office and written them a letter, not in the informal way someone might dash off a message, but a proper letter, with a salutation and clear subject line and numbered paragraphs, the way she had seen letters formatted in the writing guides her mother kept on the shelf. The automated response told her 5 to 10 business days, and so, understanding that the proper channels had been tried and had not worked, Maya had done what she had learned to do when a problem did not yield to the obvious approach. She changed her approach entirely. She began at the school. She went to see Ms. Rebecca Huang, the administrative director, after classes on a Wednesday, and explained that she needed to see the electronic access records for October 14th. Ms. Huang had been a school administrator for 22 years and had a finely tuned sense for when a situation was more serious than it appeared. Maya's manner, measured, specific, undemanding, passed every test that sense applied. Ms. Huang had pulled up the records herself and printed a certified copy, noting that the school would cooperate with any formal legal request. The cell phone records had required more ingenuity. Maya researched the legal framework online, reading through the plain language guides published by legal aid organizations in British Columbia, and drafted a request for emergency preservation of evidence that she could not have sent herself, being a minor with no standing. She brought the draft to Ms. Huang, who brought it to the school's legal representative. A quiet man named David Park, who reviewed the document, made 3 minor adjustments for accuracy and sent it on the school's behalf. The carrier had responded within 24 hours. The neighborhood canvass had taken her 2 Saturdays and 1 weekday afternoon on which she had told the school office she had a dental appointment. She had walked every commercial street within a 4-block radius of Jericho Park's main entrance, a folded paper map in one hand and a handwritten checklist in the other, entering every business with a visible external camera and asking the same questions in the same careful order. Most of the time the answer was no. Beverly Ho had been the 11th person she asked. The BC Land Title Registry search had been an accident born of thoroughness. While reviewing the company insolvency documents, which she had found through a public filing search on the government's corporate registry website, she had noticed a discrepancy between the address listed for Kevin Breyer and an address mentioned in a 2-year-old notice of pending litigation published in the archived digital edition of the Vancouver Courier. She had run both addresses through the land title search. The second property was registered under a numbered company that, when traced through 2 further registry searches, connected back to Kevin Breyer's name. She had done all of this between 4 p.m. and 10 p.m. on weeknights at the kitchen table, with the computer screen slightly dimmed so the light would not wake her mother during naps between shifts. She had drunk a lot of tea. She had not told anyone what she was doing, not because she wanted to keep it secret, but because explaining it to someone else would require a detour she did not have time for. She left the apartment at 7:50, walked 5 blocks to the bus stop on Granville Street, waited in the damp October cold, boarded the 99 when it arrived with the sigh of compressed air brakes, and got off downtown 35 minutes later. From there it was 7 blocks on foot, with the folder pressed against her chest, the wind catching the ends of her braids, her shoes making a steady sound on the pavement. She had rehearsed every step of this journey mentally hundreds of times over the past 3 weeks. She had imagined every possible obstruction, every argument that might be used to stop her, and she had prepared her responses in advance. The way you prepare for a test, whose questions you cannot fully predict, but whose subject matter you have studied until you know it better than almost anyone. Because she knew they would try to stop her. She was right. The security guard at the main entrance of the Supreme Court building was a large, attentive man whose badge read Dave Souza. He had seen in the years he had worked the entrance of that building every kind of person arrive with every kind of story. He had developed a reasonably calibrated instinct for distinguishing the desperate from the disturbed, the legitimate from the unhinged. When Maya arrived at the turnstile, he looked at her with the automatic assessment of someone trained to screen visitors. A girl, school uniform, an adult-sized leather folder. Alone. "Do you have an adult with you, young lady?" "No, sir." Children without a responsible adult aren't allowed in the public gallery during active proceedings without prior authorization. Maya had anticipated this. She took a breath, but not a nervous one. It was the breath of someone preparing to say something that needs to be said with precision. "I'm not here to watch, sir. I'm here to testify. I have information about the Mercer case. I am a witness." Dave Souza was quiet for a moment. He looked at the folder, then back at her. "A witness," he repeated, testing the weight of the word. "Yes, sir, and if you prevent me from entering without directing me to the appropriate responsible authority, you'll be contributing to an obstruction of justice." A pause. "I learned about that in Mr. Mercer's class. He was my teacher." There was something in her voice that was not calculated to be moving. It was simply factual, simply real. And Dave Souza, with his years of instinct, understood that what was standing in front of him was not performance. He called his colleague. His colleague called the court official, Patricia Lamb, a woman with short black hair and a professional expression who looked at Maya with the specific attention of someone who has learned, through experience, to recognize when something should not be dismissed. "What's in the folder?" Patricia asked. "Evidence that Mr. Mercer didn't kill anyone," Maya said, "and I know who did." Silence. Patricia Lamb took Maya to a small side room with white walls and plastic chairs, asked her to wait, and left. She returned 8 minutes later, wearing an expression that was difficult to fully read, but which contained, in the slightly raised eyebrows, something that contained surprise. "Judge Fenwick will see you." What happened when Maya walked into the courtroom was, for most of those present, the most disorienting moment of their legal careers, not because it was impossible, but because it was completely unexpected, and because reality has the unfortunate habit of ignoring narrative convenience. Judge Fenwick lowered his glasses and looked at the girl in the blue school blazer who had positioned herself before his bench, with a posture more upright than that of many of the lawyers he had seen standing in that same spot over decades of practice. "I'm told you have something to say about this case." "Yes, Your Honor." A private practice lawyer who was observing the proceedings as a professional courtesy let out a sound somewhere between a laugh and a cough. Someone in the gallery smiled. A child, in a school uniform, using the term Your Honor in a real courtroom in the middle of active proceedings. It was, objectively, absurd in a way that bordered on the comic, but no one in that room knew yet what was inside that folder. Maya did not blink. Judge Fenwick, who had seen a great deal in his career but had clearly not foreseen this particular moment, assessed the situation with the pragmatism of someone who does not have the luxury of being paralyzed by the unusual. "What is your name?" "Maya Correa. I'm 11. I've been a student of Mr. Mercer's for 2 years at St. Andrew Primary School." "Did you come here alone?" "Yes, Your Honor. My mother works a double shift today. I tried to speak with Mr. Mercer's lawyer twice. No success. I called the police tip line. Nobody called back. I sent an email to the Crown prosecution. I received an automated response saying it would be answered within 5 to 10 business days." She paused. "The trial ends today, so I came in person." Judge Fenwick looked at Ronald Chung, who had risen from his chair with an expression of genuine bewilderment, like someone who has no idea what is about to be placed before him. Then he looked at Crown Prosecutor Adriana Walsh, who maintained a neutral, professional expression, though her eyes were moving with careful attention. Some in the gallery still had the corners of their mouths slightly raised. A schoolgirl, in a courtroom, claiming to have evidence. It was clearly something to be gently managed and quickly concluded. They had no idea what was coming. "Ms. Walsh, Mr. Chung, any formal objections before I hear what this young lady has to present?" Ronald Chung looked at Daniel. Daniel was looking at Maya with an expression that was difficult to define completely. In it was astonishment, recognition, a gratitude too large for the moment to hold, and something resembling the sensation of waking from a nightmare and needing several seconds to believe it is real. "No objection from the defense, Your Honor," Chung said. "The Crown reserves the right to challenge the admissibility of any evidence presented outside the regular process," Walsh said, with clinical precision. "Noted. Ms. Correa, you may approach." Maya walked down the central aisle. Her black shoes made a steady, firm sound on the old wood floor, a small sound that echoed in a space designed to amplify solemnity. She stopped at the low railing before the bench, placed the folder on the edge, opened it carefully, and began to remove documents in order, each one with its color-coded clip, each one in its prepared place. There was something in the ritual of that gesture, the colored clips, the handwritten labels, the evident order of someone who had thought carefully before acting, that began slowly to erase the residual smiles from the gallery. Like a candle finding wind. "Your Honor," she began, and her voice was absolutely steady. "Mr. Mercer was not near Jericho Park on the night of October 14th. I know this because I was with him." Total silence. That Friday evening, as happened every Friday since the start of the school year, Mr. Mercer stayed at school after hours to prepare materials for the following week's lessons. I waited with him because my mother works late on Fridays, and Mr. Mercer would walk me to the bus stop when he left. My mother knew about this arrangement. He had spoken with her at the beginning of the year, in person, to ask her permission. She raised the first document. "This is the electronic access log from St. Andrew Primary School for October 14th. Mr. Mercer's staff badge was registered at the exit at 9:07 p.m. The witness, Robert Finch, stated he saw Mr. Mercer walking toward the park at approximately 8:40 p.m. That is a difference of 27 minutes, and the school is a 15-minute drive from the park, not a walk. He could not have been in two places at once." A murmur moved through the gallery, not of amusement this time. "Where did you obtain that record?" Judge Fenwick asked, leaning forward slightly. "I explained the situation to the school's administrative director, Ms. Rebecca Huang. She checked the records and gave me a certified copy. She said the school would make itself available to confirm this before the court." Ronald Chung had stopped pretending to be calm. He was writing with visible urgency. "There is more," Maya said, not as an announcement, as a fact. What followed over the next 12 minutes was, for those who were present, a disorienting experience unfolding in slow motion. Maya removed from the folder, one by one, with the composure of someone who had spent weeks preparing each step, documents that constructed an alternative picture and a devastatingly more coherent one of what had actually happened on the night of October 14th. There was a printed record of Daniel Mercer's cell phone activity obtained by Maya after she drafted, using research from legal information websites, a formal request for emergency preservation of digital evidence relevant to preventing irreparable injustice, addressed to the telecommunications carrier. The request had reached the carrier through the school's legal representative, who had intermediated after Maya appeared at the administrative office and convinced the director that the situation demanded institutional intervention. The record showed that on the nights preceding the crime, the calls logged against Daniel's number were received calls, not outgoing ones. Thomas Breyer had been calling Daniel, not the other way around, and that on that specific Friday night, Daniel had made 3 calls, all of them using the school's Wi-Fi network, which placed his device with geographic precision inside the school building for the entire relevant period. There was a printed still image from an external security camera belonging to a Shoppers Drug Mart on Alma Street, 2 blocks from the entrance to Jericho Park. Maya had spent an entire day walking through the neighborhood, entering pharmacies, bakeries, a gas station, and a convenience store, asking each manager or employee whether the establishment had an external camera and whether any footage from the night of October 14th had been preserved. Most had said no. The Shoppers Drug Mart had said yes. The store manager, a woman named Beverly Ho, had been so struck by the seriousness and precision of Maya's questions that she had accessed the surveillance system herself, located the recording, and provided a printed copy of the relevant frame. In the image, at 8:38 p.m. on the night of October 14th, a man was walking toward the entrance of Jericho Park. He was not Daniel Mercer, but Maya knew exactly who he was. "The person in this image," Maya said, placing the print on the railing carefully, "is Kevin Breyer, the brother of Thomas Breyer, the victim. He was walking toward the park at 8:38 p.m. The medical examiner's report places the time of death between 8:30 and 9:10 p.m. She reached into the folder and removed the final document. "This is a certified copy of a public filing from the BC Registry of Companies. Kevin Breyer and Thomas Breyer were co-owners of a real estate company that experienced serious financial difficulties over the past 18 months. 8 months ago, Kevin Breyer became the co-signatory of a $2 million life insurance policy in Thomas Breyer's name. The beneficiary in the event of Thomas's death is Kevin Breyer. These are public documents. They are registered. Anyone can verify them." The silence that settled over the room was unlike any of the silences that had come before it. It was heavier. It was the kind of silence that does not go backwards, the kind that exists in the second after an irreversible sentence is spoken aloud, in public, in the presence of those with the authority to act upon it. There was a man sitting in the 3rd row of the gallery. He was 51 years old, well preserved, with precisely cut grey hair, a dark suit of visible quality, and a wine-red tie with a perfect knot. He had arrived early that morning, when the courtroom was still settling into the day. He had chosen a discreet seat, not in the centre, not at the edges, a seat that offered a full view of the room without drawing attention to itself. He had remained still and quiet throughout the hours of proceedings that preceded Maya's entrance. Still and quiet, in the way of someone who had practiced being invisible. Nobody had paid any attention to him. While Maya spoke, he had remained very quiet. More quiet than before, if that was possible. That was a different kind of quiet, dense and inward, like the stillness of someone who realizes the ground beneath their feet is giving way and has not yet decided what to do about it. When Maya placed the still image from the pharmacy's camera on the railing, something shifted in his posture, a stiffness that moved across his shoulders from top to bottom. The fingers that had been resting calmly on his knees contracted almost imperceptibly, forming something close to a fist before spreading open again. When she said the name Kevin Breyer, the man stood up, not gradually, abruptly. The wooden chair scraped against the floor with a sharp, dry sound that cut through the air of the room like a wrong note in a concert. Several heads in the gallery turned instinctively, pure human reflex, an unexpected sound in a room that expected silence. The man began moving toward the side door, too quickly. with the kind of urgency that has no innocent explanation. His left hand was already reaching toward the door handle before his feet had closed the distance. A man who had been in that room for hours, still as furniture, suddenly in motion with the directional certainty of someone who had already decided on his exit route before he needed it. What happened next would be described differently by the 12 people who described it publicly in the days and weeks that followed. Some said he walked very fast. Some said he was already running by the time he reached the railing. The court reporter, a woman named Grace and Kemdirim, who had been transcribing proceedings for 11 years, said in an interview that she had looked up from her keyboard at the sound of the chair and seen a man moving like someone who had calculated the cost of staying and found it unacceptable. Dave Souza, who had accompanied Maya into the courtroom and remained standing against the wall with the professional stillness of someone who understands his presence may become necessary, saw him before anyone else did. There was something in the man's stride, in the speed, the direction, the forward tilt of the shoulders like a body preparing to run before it actually commits to running, that activated an instinct that did not need words or processing time to function. "Hey!" Dave stepped forward, one large hand extended. The man accelerated, and then he ran. The side door of the gallery hit the wall behind it with a crash as he pushed it open with his shoulder, not slowing, not looking back. 2 women in the gallery cried out simultaneously. A man on the aisle seat got to his feet without fully knowing why he had done so. Officer Thomas Reyes, posted near the main exit, required a second and a half to process what was happening. The sequence of sounds and movements, the running figure, the shouts, the door still swinging. And that second and a half was the time Kevin Breyer used to reach the outer corridor and turn toward the stairwell. "Stop him!" Judge Fenwick brought his gavel down against the bench with a force that echoed across the room like a gunshot. "Nobody leaves this room. Hold that man!" Dave Souza had already crossed through the door. Reyes followed a beat behind. Voices in the corridor, rapid footsteps on marble, the sound of something, a chair or a waste bin, being knocked over somewhere beyond the walls of the room, the hollow sound of it rolling. For approximately 45 seconds, which felt 3 times as long to everyone present, the British Columbia Supreme Court chamber was suspended between chaos and order, in an intermediate state where everyone was standing without having been fully aware of the moment they had risen from their seats. A journalist near the back was gripping his pen so hard it had left a mark on his palm that he would only notice later. A junior associate from a downtown firm was pressed against the wall as though it offered some protection from the formless urgency that had invaded the room. Then the footsteps in the corridor were moving toward the stairwell. Radio voices, the flat and urgent crackle of building security communication. Somewhere below, a door alarm activated with a persistent electronic pulse. The gallery doors swung closed again. Judge Fenwick brought his gavel down a 3rd time, and this time the sound was not requesting silence. It was commanding it. "Everyone sit down immediately." The room obeyed the way rooms obey judges who do not repeat themselves. And when the fragile order had been re-established, and the only sound was the distant radio communication of the security officers in pursuit, Judge Fenwick looked at Maya Correa. Maya was still standing in the exact position she had occupied when she placed the last document on the railing. Hands resting on the papers, posture upright, with the expression of someone who had foreseen, perhaps not with precision but in general outline, that something like this might happen. She had not moved during the chaos, not a single step. Daniel Mercer, in the defendant's chair, had his cuffed hands clasped together in his lap and was looking at Maya with an expression that was impossible to fully name. In it were shock, recognition, a gratitude that no courtroom had been designed to contain, and something resembling the feeling of waking from a nightmare and needing several seconds to believe it is actually over. Judge Fenwick removed his glasses, polished them with the cloth he kept folded inside his robe, put them back on, looked at the girl for a long moment, Do you have more documents in that folder? Yes, Your Honor. Then please continue. And she continued. What Maya Correa had inside the remaining portion of that folder, which she proceeded to present to the court over the following 22 minutes, with the methodical clarity of someone who had not only found the evidence, but understood its significance, was the kind of thing that makes experienced attorneys quietly wonder what they were doing while an 11-year-old girl was doing their job. She had a printed copy of a text message thread, obtained through the same telecommunications request that had produced the call records, between Kevin Breyer and a number registered under a false name, showing 17 messages exchanged in the 9 days before Thomas Breyer's death. The messages did not name anyone explicitly, but their content, short, terse, referring to a problem that needed to be solved permanently, to a meeting at a location Kevin described only as the quiet place, to a payment arranged for afterward, formed a pattern that was difficult to read as anything other than what it appeared to be. She had a photograph, taken by Maya herself on her mother's phone, of Kevin Breyer's car parked in the driveway of a property that turned out to be a second home he had kept hidden from the financial disclosure documents filed in the company insolvency proceedings that had been made public. Maya had found the property through a land title search she had conducted on the BC government's public registry website. After noticing that the insolvency documents listed only one property in Kevin Breyer's name, but a legal notice she found in the archived records of the Vancouver Courier mentioned a second address linked to the company. She had a sworn written statement from Beverly Ho, the Shoppers Drug Mart manager, describing in detail the footage she had reviewed and confirming the timestamp and the physical description of the man visible on the recording. And she had, at the very bottom of the folder, a single handwritten page that she unfolded carefully and placed on top of the other documents. "This is a timeline," she said. "I wrote it myself, based on everything I found. It starts at 8:22 p.m. on October 14th, when Kevin Breyer's car was captured on a traffic camera on West 4th Avenue, heading toward the park. It ends at 9:41 p.m., when the same car was captured on a camera on Burrard Street. In heading away, Mr. Mercer's phone never left the school's Wi-Fi network between 8 p.m. and 9:15 p.m. The room was very quiet. Ronald Chung had filled 3 pages of his legal pad and was already on the 4th. Adriana Walsh, the Crown prosecutor, had been quiet for the past several minutes in a way that was different from her professional quietness. She was looking at the documents that Maya had laid out on the railing. She was rereading things. Her expression had shifted in a direction that was, for those who knew her, almost as unexpected as Maya's arrival had been. It was the expression of someone who takes the law seriously enough to follow it even when it is inconvenient. She stood. "Your Honor," Walsh said, "the Crown respectfully requests a recess to review the materials presented." Judge Fenwick nodded once. "Court is in recess. 45 minutes. During those 45 minutes, 3 things happened. Kevin Breyer was apprehended on the 4th floor of the building, where he had run into an office used by administrative staff and locked himself inside a supply closet. Officers Dave Souza and Tomas Reyes, guided by a building security guard named Phil Morris, who knew every room in the courthouse from 30 years of maintenance work, reached the door in 11 minutes. Souza spoke through the door in a calm voice for 4 minutes. Kevin Breyer opened the door himself. He was breathing very fast, and his suit jacket had been torn at the right shoulder seam. He did not say a word as they escorted him downstairs. Ronald Chung made 4 phone calls and filed an emergency motion for a stay of proceedings and immediate review of the evidentiary basis of the case against his client. And in the small waiting room off the main hall, where Patricia Lamb had brought her to wait during the recess, Maya Correa sat in a plastic chair, set the empty folder on her lap, and for the first time since she had boarded that bus 3 hours earlier, allowed herself to breathe. Patricia Lamb brought her a cup of tea from the staff kitchen. Not because protocol required it, because it seemed like the right thing to do. "How long did it take you?" Patricia asked, sitting down in the chair beside her. Maya thought about it. 3 weeks and 2 days. Patricia was quiet for a moment. "You did this alone?" "My mom doesn't know I'm here," Maya said. There was a brief silence. "She's going to be very proud," Patricia said. Maya wrapped both hands around the paper cup. The tea was warm and slightly too sweet, the way tea from an institutional kitchen usually is. She did not mind. "He was a good teacher," she said, "not as justification, simply as a fact that needed to be said out loud." Patricia nodded. "I could tell." When court resumed 45 minutes later, the room felt different. The same wood paneling, the same high windows, the same cold October light. But something had shifted in the way people occupied the space. More upright, more awake, as though what had happened before the recess had recalibrated everyone's understanding of what was possible in that room. Kevin Breyer was not returned to the gallery. He was taken directly to a holding area under the supervision of 2 officers, pending formal processing. Judge Fenwick took his seat, set his gavel on the bench without using it, and looked across the room for a moment before he spoke. "This court has reviewed the materials presented by Ms. Maya Correa. In light of those materials, and in light of the conduct observed in this courtroom before the recess, the Crown has communicated to the bench that it is withdrawing the charges currently before the court against the defendant, Daniel Mercer, pending the results of an urgent review of the investigative basis of this case. That review will begin immediately." He paused. "The defendant, Daniel Mercer, is to be released from custody effective today, pending the outcome of that review, which the court expects to be conducted with appropriate urgency." A sound moved through the gallery, something between a breath and a murmur. The sound a room makes when it processes something that was not supposed to be possible. Daniel Mercer was looking at his hands. He looked at them for a long time, as if verifying something. Then he looked up, across the railing, toward the front of the room where Maya was sitting beside Patricia Lamb, still holding the paper cup of tea. He did not say anything. There were not, in that moment, words proportionate to what needed to be said. But she saw the look on his face, and she understood. The formal proceedings that followed that day were the beginning of something larger than any single courtroom. Within 48 hours, Kevin Breyer had been formally arrested on suspicion of first-degree murder in the death of his brother Thomas. He had retained a private defense attorney within hours of his apprehension in the courthouse supply closet, a decision that spoke to a degree of preparation that investigators would later find significant. The investigation that was reopened following Maya's intervention revealed, within the first week, that Robert Finch, the witness who had placed Daniel Mercer near the park, had been a business associate of Kevin Breyer's for several years, a connection that had not been disclosed and had not been uncovered during the original investigation. A connection that, once known, reframed his testimony entirely. It also revealed that the fibers from Daniel's jacket found at the scene had been transferred deliberately. A forensic re-examination conducted at the urgent request of the defense following the new evidence found that the sample was inconsistent with the wear and contamination patterns that would be expected of a jacket physically present at an outdoor location on a cold October night. The fiber density and distribution were more consistent with manual transfer from a garment to a surface. Someone had taken material from Daniel Mercer's jacket. From the coat hook in the school's staff room, investigators later established, where he hung it every day, and planted it at the scene. The investigation would take months to complete. A trial would follow. The legal process would do what legal processes do, move with the weight and pace of an institution that does not accelerate for the sake of anyone's impatience, even when the impatience is entirely warranted. Kevin Breyer would maintain his innocence through the initial stages with the particular composure of someone who has calculated the available options and chosen the most defensible posture. The evidence would accumulate regardless, But the most important thing had already happened. Daniel Mercer was free. He walked out of the courthouse building through the front entrance in his own clothes, a dark sweater and jeans that Ronald Chung's assistant had retrieved from evidence storage and brought to the building, for the first time in weeks, into the grey October afternoon of a city that smelled of rain and fallen leaves and the particular quality of cold that the Pacific coast produces in autumn. Damp and honest, the kind that settles into the lungs and reminds you that you are breathing. He stopped on the broad stone steps and stood for a long moment with his face turned slightly upward. He was not looking at anything specific. He was simply standing in open space, in the free movement of air, in the peripheral sounds of a city that had continued existing without caring what was happening to him inside that building. There is a quality of presence that only people who have been confined understand. He was learning it back, standing on those steps. Maya was a few steps behind him, the empty folder tucked under her arm. Her mother was there too. Fernanda Correa had been reached by Patricia Lamb's phone call during the recess and had arrived, still in her nursing scrubs with a small coffee stain near the left pocket. In a taxi, she had flagged outside the hospital without asking the price. She had come through the courthouse entrance at a pace that was not quite running, but was the fastest thing adjacent to it. And when she saw Maya standing in the hallway, her face had done something complicated and complete before she covered the distance between them. She had held Maya for a long time without speaking, with a grip that communicated everything language was not fast enough to contain: relief, fear that had not yet fully resolved into relief, love that had no edge, and underneath all of it, the specific emotion that has no name, but that parents recognize as the feeling of understanding. Retroactively, how much danger meant because of how close it had been. When she finally stepped back and looked at her daughter's face, she said only, "You could have told me." "You would have stopped me," Maya said. Fernanda looked at her for a long moment. The afternoon light was flat and even, the kind that does not flatter anything but does not deceive either. She looked at her daughter's face, the steady eyes, the braids with the blue ties still in place from that morning, the grandfather's leather folder, empty now, under her arm. And she nodded slowly, because it was true, and because she was wise enough, in that moment, to recognize that the truth was worth acknowledging even when it was uncomfortable. She would have stopped Maya. She would have found the responsible, protective reasons to stop her, and those reasons would have been real, and Daniel Mercer would have been convicted. Daniel turned around on the steps. There is a kind of gratitude that does not fit in the containers people normally use to hold emotion. It does not fit in a sentence or a gesture or an expression, not because it lacks form, but because its form is too large for ordinary moments. Daniel Mercer stood on those courthouse steps and looked at an 11-year-old girl in a school uniform holding an empty brown leather folder. And what moved across his face was something that the reporters who had gathered outside, word had spread with the speed that remarkable things spread, particularly in a courthouse where everyone has a phone, tried later to describe in their articles. They used words like relief and gratitude and overwhelmed. But what it actually looked like, to those standing close enough to see his face clearly, was something simpler and harder to name. It was the look of someone who has been returned to themselves. "How did you know?" he asked. His voice was slightly rough, the voice of someone relearning how to project sound into open space. Maya considered the question with the same care she had applied to everything else over the past 3 weeks. "I was there that night," she said. "I saw you leave at 9. I knew what the witness said was wrong because I had been with you. But nobody asked me." She paused for a moment. "Nobody asked any of the students. Nobody checked the school logs. Nobody looked for cameras in the neighborhood." Another pause. "So I did." He was quiet for a moment. "You shouldn't have had to," he said finally. "No," she agreed. "I shouldn't have." There was a simplicity to that exchange that would stay with those who overheard it. No performance, no drama, just two people standing on steps in the October grey, acknowledging a gap between what the world is supposed to be and what it had actually been in this particular case. A gap that a child had, through 3 weeks of stubborn, meticulous, underfunded, unofficial work, managed to close. In the weeks that followed, Maya did not seek the attention that came anyway. She went back to school. She completed the science project that was due. She answered the questions that journalists asked through her mother, with brief, factual responses that gave them less material than they had hoped for, because she did not understand what there was to perform about something that had simply needed to be done. Mr. Mercer returned to teaching the following semester after a period of leave and the official clearing of his name that the completed investigation produced. On his first day back, the classroom was quieter than usual, in the particular way classrooms are quiet when students are paying attention to something that matters. He stood at the board for a moment before writing anything, and then he wrote a single question in the middle of the green chalkboard in his slightly uneven handwriting. "What do you do when the system fails?" The students looked at the question. Some of them wrote in their notebooks, some of them thought. One student near the back said, "You do it yourself." Mr. Mercer looked at the student for a moment, then he nodded. The investigation into Kevin Bryer's role in the death of his brother Thomas concluded 14 months later with a conviction on a charge of first-degree murder. The motive was confirmed as financial. The company they co-owned was insolvent. Thomas had been intending to file for personal bankruptcy in a way that would have protected his share of the remaining assets, and the $2 million insurance policy had been Kevin's alternative solution. Robert Finch, the false witness, pleaded guilty to obstruction of justice and received a suspended sentence in exchange for full cooperation. The investigator who had led the original case against Daniel Mercer was referred to the Professional Conduct Review Board, a process that moved as slowly as professional review processes generally do, but that moved. None of this restored the weeks Daniel Mercer had spent in a cell, or the weight he had lost, or the particular quality of sleep he did not have again for a long time afterward. None of it gave back the days his students had spent in a classroom with a substitute teacher who was perfectly adequate and nothing more. None of it returned to Daniel the version of himself that had existed before the arrest, the version that had not known from personal experience how it felt to have the full institutional force of the state organized against an innocent person with no effective mechanism for correction. What it did was what justice, when it finally arrives, actually does. Not undo, but acknowledge. Confirm that the truth was always what the true person said it was. Establish in the public record what actually happened. Hold the right person accountable. And send the message, however imperfectly and however late, that the system had corrected itself, that the correction had required an 11-year-old girl carrying her grandfather's folder across the city on a cold Tuesday morning was a fact that the system did not celebrate, because systems do not celebrate their own failures, but it was remembered. Maya Correa remembered it the way you remember the thing that taught you something essential. Not with bitterness, not with pride exactly, but with a clarity that does not fade. She remembered that she had been small, and that being small had not prevented anything. She remembered that she had been ignored, and that being ignored had simply meant she had to find another route. She remembered that she had been 11 years old and afraid, genuinely afraid of walking into a courtroom full of adults with authority, and that being afraid had not stopped her from walking in anyway. She remembered, most of all, that someone had taught her to ask good questions, and that the most important thing about a good question was that someone cared enough to ask it. If this story moved you, share it. Stories like this one deserve to be told, because they are true in the way that matters, true to the reality that justice does not arrive by itself, that the system fails real people at predictable points, and that sometimes the correction comes from the least expected direction. Because one voice, even a small one, even an unexpected one, even one that enters through a side door in a school uniform carrying a worn leather folder, can be enough to change everything.